And here's the $120 that the woman gave me. Hi, Penny. Hi, Penny, Penelope, Penguin. The day starts at 5 a.m. on the knees. Thank you, God, for another day. And thank you, God, for a day in this beautiful world you have created. This is the errands box. Why is it things will not lean the right way? These pouches were irresistible, and I couldn't figure out what to use them for. But Rita says Glendora is very organized, like Penny. This errand box we found at the dump in Lindbergh. Well, it was in the hallway on the way to the dump. So such a nice box. We painted it and made it the errands box. Franklin paid the rent. It costs $45 a day to live here. Franklin is paying the telephone bills. MCI was, how much, Franklin?
$25.80.
And this number here, how much was that?
$84.52.
In Huntington, that's usually about 15. And 9495, that's usually about 16. This is a map of what happened yesterday. This log is the short log, and it goes to Brad Sachs, goes into the Dolan file. A copy goes to Franklin, and a copy goes in the Bruiser Ken file. It takes practically a quarter of the day to make out the to-do list, what has to be done today. This is all of the things that didn't get done yesterday. So you have to add them to all the things that have to get done today. I should think it would take about 5 days to clear this up. 4 legal papers today. You know, and the details, there's about 20 details. And there's about 20 telephone details that didn't get done that were urgent to do. Now they got to wait until after Labor Day. That's bad. Like calling the courts and finding out the status of the cases, getting tapes to Mount Vernon High School. All has to wait now. This is Labor Day Saturday. New York Tel to 9X to Bell Atlantic and now Verzon. You see, we're undoing all of the great work that Judge Green did, busting up AT&T. All of the public's benefits are being undone. And here's the pile of work to go through in addition to the legal papers. So it's 10 o'clock. Here's the first legal paper. The cheater, U.S. Court of Appeals, Boston. The cheater, Chief Judge, and the District Court there, William Young. The cheater, Chief Clerk there, Anastas. Boston is a cheater court. Now we have to start rotating the tapes. This is Friday's job, but you know what happened to Friday. It was ruined by the Dolans. Load of tapes that Franklin brought back Thursday from Harrison, White Plains, Rockland, Peekskill, and Yorktown. He was all day doing this. So these are the boxes out of the video closet. The 3/4 inch box, the return box, tapes that are returned, the VHS box, and this is the empty Wednesday box, which has to be filled up in preparation for next Wednesday to label tapes for the following Tuesday, which would be September 12th. Today is September 2nd, Labor Day Saturday. Those are the hidden truth. Franklin has done his work. All of his tapes are rotated and the Wednesday box is done, and Glennie has to put them back on there. And while Franklin did that, Glennie wrote to the Cheater Court, United States District Court, Boston, and the United States Court of Appeals, Boston, First Circuit. And the trusty machine printed it all. So let's get those into envelopes, and Franklin wants to go to the bank. He wants to get the Social Security checks and the pension checks, and he wants to get them in the bank. So that's the trusty machine printed it all. So let's get those into envelopes, and Franklin wants to go to the bank. He wants to get the Social Security checks and the pension checks, and he wants to get them in the bank. So let's get this into the post office at the same time. Legal paper number 1. This is from a very queer court. The United States Court of Appeals for the First Circuit, that's Boston. And here is what they write. On Glendora versus a plaintiff appellant versus Eugene H. Nickerson, Hillary Indira, his law clerk, and they left out another law clerk, Marilyn D. Go, Todd Manister, Michael J. Goldberger, Zachary Carter, Robert Sweet, Stacy Nera, his law clerk, Lawrence Nevins, Rachel Godsill, Mary Jo White, Alan G. Schwartz. These are all defendants of appellees, and a whole lot more that they left out. Ralph K. Winter, George Lange III, Carolyn Clark, they've got it, it's Carolyn Clark Campbell, Lucille Carr, Robert Rodriguez, Guido Calabrese, Milton Pollock. These are all judges. Christopher F. Droney, judges in the Second Circuit. Gladys Kessler, Norma E. Johnson, Nancy M. Mayer Whittingham, and that's misspelled. She's the chief clerk in the D.C. Circuit. George A. O'Toole, another crooked judge in the First Circuit. Tony Onassis, the cheater chief clerk in the United States District Court, Boston. John P. de Blasi, we all know who he is, the judge who cheats repetitively and has been caught by me and by Gannett, and his law clerk Schwersky. U.S. West, Richard D. McCormick, the former CEO, Charles Lillis, the one who ruined Continental Cable TV, which now goes to AT&T, Joseph Panio, the crooked local rent administrator in White Plains for the New York State Division of Housing and Community Renewal, Joseph M. Lynch, its acting director, and they got George Patsky. It's George Pataki, the governor of New York. This is this illiterate caption, and it's wrong. Anyway, received by Glendora, August the 3rd, 2000, Thursday. Memo endorsed by Glendora on September the 2nd, 2000, Saturday. 1. You are a cheater court. Glendora never filed Glendora versus Nickerson in Massachusetts. Glendora versus Nickerson was filed in Philadelphia. You have been told that several times. Produce the civil cover sheet. You cannot. Produce the filing with a United States District Court, Boston, on it. You cannot. You lie. You cheat. Now, what they say is that this is a notice of default and intent to dismiss. Well, they never had the case in the first place. By notice dated March the 29th, 2000, the clerk of this court notified you that the docketing statement was due in the Court of Appeals on April the 12th, 2000. The appellant is presently in default as to this filing. That's because the appellant was never in that court, and the plaintiff was never in that court. The appellant is ordered to file the docketing statement by September the 11th, 2000. Failure to comply with this order will result in the dismissal of the appeal for want of prosecution in accordance with Local Rule 3B. Who cares? Who cares? And you can see what the phony signature is. Now, 2. Glendora never filed a notice of appeal on Glendora versus Nick in the First Circuit. Produce one, signed by Glendora. You cannot. You are a cheater court. You are a liar court. And Glendora says it's not a signature, therefore it's not an order, and therefore it's not signed by a judge, so it's a nullity. You are cheaters. Glendora demands you send her the record on appeal. Page 2. You tampered with the record, and you will be charged with 18 U.S. Code Section 1207. Glendora is not in default. A, she never filed in this court. B, she answered every one of your lies and cheats. You are a disgrace to New England. You are anathema to the Pilgrims. How can the same case be in 2 different courts simultaneously? We bought you Pacer. That's the computer. Read it. Now, here it is again. And Glendora says, not only do you have the wrong court twice, the United States District Court and the United States Court of Appeals, you can't even get the caption right. And here are many of their errors in the caption and many names that they left out. Dumb, dumb, dumb. So we go on to page 4. Here is the caption, and you notice that it was filed in the United States it was filed in the United States District Court, Philadelphia, and it was appealed in the United States Court of Appeals, Philadelphia. That's the Third Circuit. And here is the caption. Some of it is right, and it's a whole lot more right than the Boston caption. These are mostly judges and law clerks and court clerks. So now we're on to page 5. Why don't you people earn an honest living? Why do you betray the United States of America every day? Send Glendora the record on appeal, and without cheating. You have provided Glendora with the documents she needs to sue you. And what cheat are you going to attempt when Glendora sues all these defendants again, plus the United States District Judge in Philadelphia and the United States Court of Appeals in Philadelphia because they did not rule on the merits? Remember, you tried to pull a similar cheat when Glendora sued your Chief Judge, William Young, and your Chief Clerk, Anastas, in the United States District Court, Houston, and the United States Court of Appeals, New Orleans. Shame on you for betraying the USA. What cheat are you going to attempt when Glendora sues Young and Anastas again? Res ipsa loquitur. Your record speaks for itself. You file cheat documents in the record and think that's going to be the record for future generations. But the real record lives in the Glendora Pro Se and Public Access Museum. And on the videotapes exposing you. Page 7. You have never been able to meet Glendora's demand. Produce a notice of appeal. United States Court of Appeals, Boston, signed by Glendora. One doesn't exist. You cannot. You are liars. You are sleaze. The public despises you. Did you make out a notice of appeal and forge it? Did you erase the United States District Court, Philadelphia, and print on United States District Court, Boston? Shame on you. Glendora has the telephone audio tapes on recorder. How low can you get? And this is the last page. Cheaters, idiots, traitors, what fools you make of yourselves. Anastas is the one in default, Young is the one in default. Never defended themselves, never answered the complaint against them. Not filed in the United States District Court, Boston, but in the United States Court, Philadelphia. Aren't you ashamed of yourselves? As an American, you are zilch. Desperation trying to put false records into the archives. You will all be sued again for this betrayal to the USA. And there's the service list, Glendora TV audience, that's you. The Center for Judicial Accountability Incorporated, the Chief Judge of the First Circuit, the Chief Clerk of the Boston Court, United States District Court, and who to sue. So the copies are all made and the envelopes are all addressed and stuffed, and Franklin's going to mail them when he leaves in just a few minutes. The video closet is all intact except for one box. Remember, Muhammad would never disturb a cat. So that will have to stay out until she's through with it. Franklin left. We didn't have time for breakfast. So I'll get a breakfast and it'll be cold supper for Franklin. The minute Ginny heard the dishes rattle, she got up and went to the kitchen. She's a very simple, straightforward cat. One meal a day. It starts at 5 o'clock in the morning and ends at 9 o'clock. Let's read this while we're having breakfast. I just found out it's lunch. It's 12:05 p. This came from the United States District Court in Little Rock. And this is good. They have filed my my lawsuit, Glendora versus the New York Law Journal. You see the date of file there, and then you see it has a number, 400-Civ-0641, and has been signed to a judge, JMC, it's a magistrate. This case is signed to magistrate judge, and you really can't read it. Glendora plaintiff versus Bruce Wassenstein, the owner of American Lawyer Media Incorporated, George M. Dillahay, Lee Jones, and Julia C. Mead. Those are the people who wrote everything good about Cablevision and everything bad about public access and Glendora. You remember this case, I read it to you. And this statement says, in the United States District Court, Eastern District of Arkansas, Western Division, Glendora versus Wasserstein et al., case number 400CB, that stands for Civ 641. JWC is the magistrate. Plaintiff, list first one named in the complaint. Defendant, list first one named in the complaint. On this blank day of blank 1900, they should have erased that. It's 2000. I, being a party in this civil litigation, certify that I have received a copy of the publication entitled Your Day in Court. The federal court experience, and have read or had read to me sections 2, 3, 4, 6, and 7 thereof, and also that part of Rule 11 quoted on page 26. And I further certify that I understand the requirements imposed upon me as a party in this civil case. If I have an attorney, I understand that I should discuss with him or her any question I may have as to our respective duties and responsibilities during the pendency of this case. If I represent myself pro se, I understand that I should contact the clerk's office if I have any such questions. Okay, that's pretty good. But really, I don't think there's any statutory or constitutional basis for this. I think it's illegal. And then there's a note dated and the client. Note, this certificate must be filed with the papers in this case within 20 days of the time a person, corporation, or other organization becomes a party to any civil action in this federal district court. If the party is not an individual, then this certificate must be signed by the officer or agent of the corporation or other association who has the authority to oversee the litigation and make binding decisions on behalf of said party. If the party is an infant or otherwise incompetent, that would be all of the dependents are all incompetent. This certificate must be signed by a person having the legal authority to speak for and to make decisions on behalf of the incompetent party with respect to the litigation. Alright, so what's the first section? And have read or had read to me section 2, 3, 4, 6, 7, and rule 11. So let's read section. It's pretty interesting, this book, and I'm writing a memorandum about it. In the outdoor office, you can hear the thunder. It's raining for a change, folks. Labor Day Saturday, September 2nd, 2000, Anno Domini. The United States District Court, Eastern District of Arkansas, Western Division, Glendora. Case number 4 CV 641 JWC, Glendora versus Wasserstein et al. Memorandum by Plaintiff Glendora. Hello.
Hello.
How was your trip to White Plains?
Very good.
It's raining pretty hard now.
Yeah.
Can
I got time to eat this?
Okay. Glendora thanks you for filing her case for the docket number and the USMJ. That's United States Magistrate Judge. You know, magistrate is just a teacher's helper, that's all. Your Day in Court is an interesting booklet. You did a good job. Who is Glendora's Article 3 judge? She did not sign a 628 U.S. Code Section 624 consent form. You see, folks, you're entitled to an Article 3 judge. The Constitution, Article 3, gives you a district judge. And they can only make you take a magistrate if you sign a consent form, and the number of that consent form is 624. Glendora read Section 2, but it does not apply to her. She is indelibly pro se. Respect cannot be mandated. Lawyers have to get their respect the old-fashioned way. Earn it. Glendora belongs to Americans for Legal Reform, Long Island chapter. We picket lawyers. Indeed, we picketed the American Bar Association July 8th at the New York Hilton. Glendora knows of only 3 lawyers out of the 500 she has encountered to tell the truth. You're page 7. Section 3. Oliver Wendell Holmes was a good lawyer, and so was Abraham Lincoln. Glendora has doubts about Grover Cleveland. He came from the same city where we lived 27 years and where Glendora's husband was a reporter in the Buffalo News. Are you glad you were mentioned?
Oh, yeah.
Now owned by, what's the name of the man who owns Buffalo News?
Warren Buffett.
Warren Buffett. America's richest man.
No.
He was listed in Forbes that way. Glendora has never known USDJs, that's United States District Judges, to impose Rule 11 sanctions. They have always been patsies. Glendora has never known U.S. District Judges to follow Rules 26 to Rule 37. They are really remiss. Those are your discovery rights. And judges do not follow them. Glendora has known Southern District of New York United States District Judges and United States Magistrate Judges to ignore entirely lawyers leaving the case without court permission and lawyers providing proof of authority to represent. With 3 exceptions, Glendora has never known lawyers to be honest, candid, and careful. So I got all wet, went out to the 93 Lincoln, got the CBS umbrella out of the trunk so Franklin would get dry, and walked him to the car, kept him dry, and just as soon as he gets into the car and drives off, the sun is out. Okay, I did section 4 and section 5, and it's still drizzling. And I will have to read this to you. Sunshine again. Happy cat. Cat sleeping on the floor of the front porch. A nap on the floor. Meditate, create, and a new calendar for September. And the think drawer. These are things you don't have time to think about. So you put them in the think drawer. Also, there's very valuable papers there that you need for quick reference. And you have to review what is in these folders. Now what would you do with that? What would you buy with it? If I had $23 million, I would help animals. I would help the church. I would get somebody to do the legal papers. I would get somebody to do a chat with Glendora. And I would go to bed early. And I would sleep. Here's the third happy cat. What would you do, Penny, if you had $1 million? Legal paper number 3 was the lawsuit against the New York State court officer who went berserk. berserk. And the service was on August the 7th. Therefore, on September 7th, they had 30 days to waive the cost of serving the summons and answer. They chose not to be heard from. So, I make a motion about Bruiser Ken in the Second Circuit. We're recovering slowly from the Dolans yesterday, taking the whole day. This is the list of telephone calls. That's terrible. That'll have to wait until Libra. Look at that. 2 whole columns of telephone calls, plus the regular calls. List of details. Franklin isn't back yet. Next is Pray Saturday. The car just went down the street and it was a Lincoln. And it was a Red Fox taxi. This is a movement that started in the past year. People using Lincolns for taxis. He's back. That's a relief. It was a year ago, August 31st, that Franklin fell. And then he fell again on December 23rd. Say about default judgments?
I should think they'd be automatic,
Yeah, you would think so, wouldn't you?
but they don't ever happen.
Yeah,
There is no such thing.
that's right. The judges aren't doing their jobs, right?
Right. Right.
We do a lot of writing.
Get away.
Do you like it?
Mm.
This is legal paper number 4. This is a circuit judge, and it's sent to the court, 601 Market Street, Philadelphia, the right zip code, and it's returned because he's unknown. Now, isn't that funny? Isn't that a riot? Now, what are we going to do with this? Let's send it back and say, I want a judge who is not a nobody. See, this is in relation to Bruiser Ken, Glendora versus Nickerson, those crooked people. And how they didn't stand up for you, and they didn't stand up for America. And they did not stand up for what is right. Man's man. And here's the letter. Glendora wants a judge who is not a nobody. Yours in truth, Glendora. And let's do justice on Glendora versus Philbin. It should not take this long. Oh, those terrible people. And with Bob Hope's picture on the back. Okay, let's take this one out. De facto, I forgot where we left off on the chronology, the cable TV public access journal last night, Saturday, September 2nd. But let's see. I told you about Man's Man, right? Yeah, okay. And after Man's Man, we did some telephoning. And there were 25 messages on this phone, or rather on the White Plains phone. And there are 3 or 4 in Huntington. And so that took 10 calls. And then to return all the calls took about 7 more. And the next job after that was the legal paper number 5, which is file paginate, hours and dollars, Dawn. It turned out to be 60 hours that we worked on the Dawns last week, fighting their greed. I think it's a terrible thing what Charles Dolan has done, taken all the money away from the shareholders and given it to his families. The Class B shareholder list is nothing but Dawns, nothing but Dawns, and I think that's a terrible thing he did. Extremely selfish. And then we spent $206 on the Dolans last week, trying to make people aware of their greed and trying to make them obey the law. And so then we had to file paginate hours and dollar Bruiser Ken, hours and dollars Street Cleaner, hours and dollars Kasari, hours and dollars Golf, and the hours and dollars Levin. That was the Rosen paper. Remember the Rosen paper that we worked so hard on Thursday and got out? And so then what happened? Then I have to help Franklin into the bathtub and out of the bathtub and make sure he doesn't fall. Remember, it was a year and 2 days ago that he fell and couldn't move. And he was in a wheelchair for days and days. Remember that? Last year? And these are Franklin's polka dot shorts that Glennie bought him. Remember de Blasio? The judge that I caught cheating 2 years ago and exposed? And now he got caught cheating again. De Blasio spends time in a TV class and not in court. He missed 31 mornings in court. And Gannett caught him. Congratulations, Bruce Golding. This Thursday, 2nd Circuit, before 3 judges, Glendora, Bruiser Ken. This is the oral argument, telling the lies that Edgardo Ramos' gang told, and the abuse of your government, the abuse of the United States of America. Now I have to read you the Funeral Planning Society and your rights as a cable TV subscriber, the FCC fact sheet. That'll probably be on another edition. It's Sunday morning now, and it's 6. So the hard thing is to climb up in the closet and pick out a hat. The color for this week is purple. He says, or other entity residing in or serving the Cablevision service area that is illegal. What is your legal basis for that? Again, quo warranto. And that's page 28. Okay, this is page 29. Unfortunately, I had a battery problem. I don't know exactly what it was. And I missed her piece. Let me go over and see what it was. Good heavens, it's in Russian. It was Chopin. It was a beauty, and I'm sorry I missed it. Call a friend at Christ United Methodist Church. Glendora and Franklin are there. And Roberta. Read scripture and fellowship time. Kathy, now he's a good cook. So we confirmed that. He's a lawyer for Time Warner. Declaration. The restoring of the 1980 Lincoln is over. I declare it to be over. We can't find anybody to get the rattles out of it, the noises. We can't find anybody to restore the message center. So, it's over. Those were the last two jobs. It cost $11,500 to restore it. It took 385 hours. Decoration, restoring the 1980 is over. Piece that you played.
I played Wedding March in Trondhaugen by Edward Grieg.
And that's, you said, where he lived?
It was his villa was there.
His villa was there.
Yeah.
Uh-huh.
And he probably watched this wedding procession and wrote march.
You like Grieg, do you?
Yeah. I like good music.
You like good music, yeah?
Yeah.
Who got you interested in music?
What?
Who got you interested in music?
Who got? Oh, I think I did it myself. Mom invited me piano teacher when I was 6 years old. So
6 years old?
It was starting, actually, Mom guided me.
And you liked it right away?
Yeah, from the first time.
Really? And then you taught yourself the organ at 11?
Oh, yeah.
Right?
No, much later.
Oh, much later?
Yeah.
When?
Much later. I don't remember already, but much later.
And this was
We didn't have organ at 11.
Oh, okay. And this was where? In Russia?
It was in Russia.
Mm-hmm. Yeah. You love music, right?
Yes, how you can notice it. Did you notice it? It's cat.
This is what's so cute. He just comes out of his skin. He just can't stay in his skin. He just doesn't know how to express his joy. Ready to go for a ride, Rocky? Look at that tail go. Ready to go for a ride, Rocky? Do that again for me, Rocky. Come on, jump up on your bed. You love your bed, don't you, Rocky? Yeah, you love your bed. You got enough blankets? Glennie gave you her best blanket, you know. Yeah. Looks like they're going to do your floor over, Rocky. They're going to give you a new floor. And this is your TV set, right? And you got a stereo, have you? It's a nice apartment you have, Rocky. And your laundry room. Let's look at your laundry room. Brand new washer. $1,200 washer. Rocky, come here. I'll sit on your bed with you. Come here, Rock. What a great dog. Yeah, he sits right down just like a little gentleman. This is all over the place, huh, Rod? Okay, you want to go for a walk? All right, let's go for a walk. You have a back door and a front door, don't you, Rocky? That's what he's showing us. He's showing his back door. We have so many toys, Rocky. Your garden's beautiful. Your garden is all beautiful. And your tomatoes, Rock? To go for a ride, Rocky? See, this is Rocky's dogmobile, but And he's the one who made it cost $11,500. Hi folks, these are your protections as a cable TV subscriber. Your protection of subscriber privacy. They can't give the information that you give them to anybody without your permission. And we read that to you before. This is page 27 of the Cable TV Subscribers Protections from the Federal Communications Commission fact sheet. Hi Penny, you here to have your ear scratched? Can you wait a second? Can you wait to have your ear scratched? She looks right at me. She turns her head upside down. Scratch her neck. Complaints, investigations, and inquiries. Penny left. If you don't do what she tells you to do right away, she just leaves. Now, under the dual jurisdictional approach to cable television regulation, they say dual, they mean state and federal, but this is really triple because there's municipal regulation too. Several important areas of regulation are administered by local franchising authorities rather than by the Commission. And in this paragraph they do not mention public access. And this paper really is not public access friendly. It says in most cases the local franchising authority will review the charges for basic cable service and equipment to determine if the charges are justified. So you don't take that to the FCC and you don't take it to the Public Service Commission, you take it to your town, your municipality, the franchisor. Pursuant to the 1996 Act, the Commission's authority to regulate the rates charged for cable programming service was terminated on March the 31st, 1999, and that's too bad. That's where your government doesn't look out for you. That's where your government listens to the money, listens to the big guys. They lobby Congress, okay? They lobby Congress. They exchange favors, and that's bad. The Commission is particularly interested in interference problems to cable service generated by citizens' band or amateur radio operations. Requests for special relief. You can make requests to the Federal Communications Commission for special relief. A cable system operator, broadcaster, franchising authority, and under certain circumstances, individuals, that means you, the public, by filing a petition for special relief with a filing fee, may seek special relief or a waiver of any rule relating to cable television. Hey, why don't we make a petition to get rid of this local resident requirement? So why don't we do that? That cable operators and public access operators will not cablecast your program, will not cablecast non-resident programs. Demonstrating the need for relief and should show how granting the request would serve the public interest. Not only that, it's the law. And you send this to Washington, D.C. And then there's another one in Pittsburgh, Pennsylvania. So call me and I'll give you these addresses. Show cause orders and forfeiture actions. In response to a petition or on its own motion, the Commission may issue an order to show cause or initiate a forfeiture proceeding. They can make Cablevision pay. That'd be good. Such petition usually seeks to remedy an alleged violation of the Commission's rules. A copy of the petition should be sent to the cable system operator and to other interested parties. We ought to try this, Goldberg and Hillgardner. Forfeiture authority. Let's see the one that the FCC imposed on Dolans 3 months ago. They made the Dolans pay a fine. Do you remember how big it was? And it was concerning must carry. So the FCC has forfeiture authority. We are on page 29 of the FCC fact sheet. The Commission is continually in the process of adopting new rules or amending existing ones to ensure the regulations serve the public interest. Well, that's their job. Their job is to serve you. Anyone may petition the Commission to adopt a rule at any time. Now let's ask our reference librarian for this one. What the Commission does about these things is published in the Federal Register, which is available in many large libraries. I will go to Pace University Law Library. They hate the public. And I will make them produce the Federal Register because it's a document by the Superintendent of Documents, and they are an official depository for the United States government. So they have to let me in, and they have to let me see this. Citizens' participation in Commission regulation. You can call the FCC at 1-888. Call FCC. 1-888-225-5322. Let me write that down, and the next time I do character generator, if I have a chance, I'll put that up on the screen for you. 888-325-3222. Those 800 numbers are no good. The Commission Assistance, the Consumer Assistance Branch, maintains and disseminates general information bulletins on the functions and organization of the Commission. Historical information, is that historical or hysterical? Historical information on Commission actions and policies as they relate to its minority ownership policies, and fact sheets that provide concise information on policy changes and information concerning non-telecommunication services. As part of its ongoing outreach activities, the Commission holds a monthly brown bag luncheon series on issues and recent policy changes. Where do they do that? When? It sounds like Paranoids Anonymous. Paranoids Anonymous, if you want to meet with them, it's hard to do that because they won't tell you where they meet. The Commission's Office of Public Affairs issues public notices of the filings of cable TV, and comments filed may be obtained from the Commission's duplicating contractor. No, that would cost too much money. They give the number here if you want it. Television digest, electronic media, and multi-channel news. Multi-channel news is no good at all because its customer is a cable operator and everything in there is pro-cable operator. We are up to page 31. Cable system format. Forms, rather. Form 32-5A is their annual report. This report is required to be filed by every cable system on an annual basis. The Commission sends these forms to the operator and requests verification of the accuracy of the information on the form. I think we could see that in the Cablevision public file over in Woodbury. You asked for Jeff Clark. Form 394, application for franchise authority consent to assignment or transfer of contract of cable television franchise. Contract of cable television franchise. Now we want to know if they did that with Media One. Allegedly, Cablevision swapped Boston with AT&T Media One for Ossining in Westchester. Sounds to me like a bad trade. But let's see if they did that. That would be Ossining, I said, but it goes up to Peekskill. That's where they're centered now. Governor Pataki's hometown. Form 1200, setting maximum initial permitted rates for regulated cable services. Here's another one that's of interest. Form 1215, a la carte channel offerings. See Cablevisions. Okay, this is 32, page 32. Form 1240, annual updating of maximum permitted rates for regulated cable services. Let's see Cablevisions. Franchising Authority Form. Form 328, certification of franchise authority to regulate basic service rates and initial finding of lack of effective competition. Cablevision has no competition on Long Island. Cable system additional reporting requirements. No form required. Media One, Portsmouth, New Hampshire. They have to have a current address, and you send the mail to Portsmouth, New Hampshire, and it comes back to you from a cable company. Moved, forwarding address expired. Fly-by-night company. And then how to obtain information. Due to budgetary constraints, the Commission is unable to supply copies of the regulations and orders free of charge. You see, where does the money go? To their lunches, it goes to the golf games, it goes into the pocket. Making the bulging pockets of greedy cable operators and here is the last page, and that's my chart of how many hours I spent on this. This was sent to the chairman of the FCC and to the Public Service Commission and to Charles Dolan. Or through the internet at the following addresses. Gopher site. And it gives the numbers for it. And I really don't go for this. And obtaining further information from the Commission. The Cable Services Bureau is located at 445 12th Street, Southwest Washington, D.C. General inquiries should be directed to the Federal Communications Commission or call that number that I gave you, 1-888-225, oh no, it's a different one, 225-5322. This is a toll-free call. Okay. We have done it. We have read the FCC fact sheet. And I hope that has helped you. Because you have rights as a cable TV subscriber that are being trampled on daily. Folks, I've been urging you to join a funeral planning society so that things won't be left for the last minute and you won't get ripped off and you won't your life savings won't go down the drain. And it has federal benefits. In some cases, veterans and Social Security recipients are eligible for benefits at the time of death. Veterans must have a service-connected disability or be in a veterans hospital to qualify for a death benefit. Any veteran may be interred in a national cemetery. The three in this metropolitan area are Calverton National Cemetery, North Carolina, Calverton, New York, Cypress Hill, North Carolina, Brooklyn, New York, and Farmingdale, North Carolina, Farmingdale, New York. And for further details, call the Veterans Administration, the blue pages of the telephone book. Social Security may pay death benefits to the surviving spouse or minor children if they meet certain requirements. Call the Social Security office for requirements, blue pages of the telephone book. Be sure you plan your death, plan your own death. Have it all planned ahead. Make it easier for your survivors and make sure you get what you believe in. BronxNet sent out a schedule for public access producers to have studio time and to order remote equipment. And the fourth quarter facilities resource scheduling. And below is a revised list of procedures used to schedule resources for the fourth quarter. We mailed renewal forms on Monday, August 7th. Advanced bookings will continue on a monthly basis. Only certified producers who return their completed renewal forms by the due date. And the resource booking hours will be Monday through Friday from 10 a.m. to 5 p.m. And the schedule is as follows. On Friday, September 8th, we will book live studio bookings only. Producers should contact Bronx Neck Programming Office in advance to coordinate air times. They don't air, they cable cast. On Monday, Tuesday, and Wednesday, September 11, 12, and 13th, producers can book October weekend and weekday prime time, 6 p.m. to 11 p.m. resources only. When weekend and weekday primetime slots are exhausted, then any remaining slots can be booked. How do they keep people from lining up at midnight at the door? So, this morning before church, I wrote this letter to Tom Garger. And it says that Glendora opines that nothing could be more burdensome than Cablevision Public Access Kit number 3. But this may come close. Glendora will be glad to keep you apprised of whatever is going on in her 23 cable systems. If you look like your passport photo, you are not well enough to travel. When is the next meeting of the Public Access Producers Advisory Board? Yours in amazement, Glendora. Do you know there are 112 working day hours in the week? 16 hours a day. If you sleep 8 hours, you got 16 hours left. 16 hours times 7 is 112 hours. Of those 112 hours last week, we spent 60 of them going after the wrongs caused by Cablevision greed. 60 hours were spent on the Dolans. The oral argument on Glendora versus Bruiser Ken and the lying U.S. Attorney, Edgardo Ramos, is coming up this Thursday, September 7th at 10 o'clock at 40 Foley Square. John P. de Blasi, the judge, Westchester Supreme Court, State of New York, got caught cheating. Instead of being in the courtroom, he was out taking classes and being a TV host or something. This is the Eureka vacuum that I gave to somebody to give to somebody poor. He hasn't got the belts on yet. I got the instruction, the owner's manual, from the first fella I gave to give to somebody poor, but since he didn't get moving on it, I took it back and gave it to the second person, and the second person hasn't got moving on it yet. You see this man? That's our church bulletin this morning. That man is Jimmy Carter, and he's out helping people get homes by building homes. So we'll close with the joke of the day. Bob and Joan are celebrating their 7th wedding anniversary. 7th wedding anniversary is your 10th wedding anniversary, and it's 7 years of eating out of cans. Said over in ancient Greece, he said, this building has been here for over 300 years. Not a stone has been touched, Nothing has changed, nothing replaced, and the tourist said, they must have the same landlord we do. This came in the mail Saturday from the United States District Court, Southern District of Indiana, Indianapolis Division. And it's the case of Glendora plaintiff versus Joseph Trafficante, Neanderthal, New York State Court Officer number 1764, Chief of Court Security, City of Mount Vernon, and Francis A. Nicolai. Now this is the case, you heard it in great detail, where this crazy New York State Court Officer attacked me and my camera, and all I was doing was going into this city building to pay a parking ticket. And so I sued him, and this is what came back. Entry concerning selected matters. The court, having considered the above action and the matters which are pending, makes the following rulings. The plaintiff's request to proceed in form of papyrus is granted. Glendora says thank you. This action is dismissed pursuant to 28 U.S. Code sections 1950 A1 and AE2 as legally frivolous. What is frivolous is this order. In the sense that the complaint fails to set forth an arguable claim for relief. That's a lie. Because there is no plausible claim in the complaint. That's the second lie. Which would support the exercise of in personam jurisdiction. That's a third lie. Over the defendants based on the incidents alleged in the complaint. He doesn't need in personam jurisdiction. He can have jurisdiction over them without in personam jurisdiction. And the bad thing that this judge did, his name is S. Hugh, H-U-G-H, Dillon, D. Donald, I-L-L-I-N, Judge, United States District Court. The worst thing that he did is that the defendants had until September 7th to waive the cost of serving a summons, which would have given the court in personam jurisdiction. If that's what he wanted, he would have caught it. And he gets out this order before September 7th. Before the defendants have a chance to fill out Federal Rules of Civil Procedure Service, Rule 4D. Judgment consistent with this entry shall now issue, it is so ordered. And Glendora had a few things to say about that. It's vague. It's superficial. The judgment is inconsistent. He says it's consistent with. It's inconsistent. He's a bad job, I wrote on it. I'll bring it over and show it to you. And I'll send it back to him. Along with what's it say down at the bottom? Haste makes waste. So let me start at the beginning here. Here it is. A notice of motion and motion for relief from judgment. I want a relief from his judgment. Pursuant to Rule 60B, B-boy, Federal Rules of Civil Procedure, or, in the alternative, that Dillon, D-I-L-L-I-N, recuse pursuant to 28 U.S. Code sections 144 and section 454. The movement is Glendora. The return date is September 17, 2000 at 9 a.m. The location is Courtroom of Hugh Dillon, United States District Court, Indianapolis, Indiana, 46204. The relief requested is stated in the title supra. Legal bases are also stated in title supra. The grounds are apostasy, A-P-O-S-T-A-S-Y, failure to uphold the Constitution of the United States, Article 3, inter alia, self-interest versus public interest. You're the public. He's interested only in himself. Supporting papers are the affirmation affixed here too. All defendants have been served a true copy of the within notice of motion and affirmation in support. The service was by U.S. mail on September 5th, 2000, Tuesday. White Plains, New York, September the 5th, 2000, Anno Domini, yours in truth, Glendora, a chat with Glendora, address, etc. And the affirmation says, you are a bad court, and I want you to do this paper over. It is this order that is frivolous. This is anything but a frivolous complaint. A good American could see that. Shame on you for not doing your duty. This is a Rule 60B motion, Federal Rules of Civil Procedure for relief from judgment. What you did is an Indianapolis Speedway treatment. You can do better. Glendora will have to bring this action again. You did not adjudicate on the merits. This does not help the problem of congested federal court calendars and people waiting for justice. You did not notify all parties, Rule 77, Federal Rules of Civil Procedure. Thank you for granting the informer pauperous, but you had to in order to dismiss. You have to reconsider. That was a bad thing you did. Indianapolis court is no good. You say dumb things. Obviously you are protecting another judge. It is self-interest versus public interest. This is not a police state where people go in to pay a parking ticket and get attacked by a court officer. This is a case of police brutality, and you are on your own selfish side and not the public's. Glendora sued 2 judges. As a judge, you don't like this. She sued a Neanderthal court officers whose job is to protect bad judges. And you don't like that. Glendora needs a judge who remembers that the courts belong to the people. The rest is reserved. Wherefore, Plaintiff Glendora seeks relief from judgment or recusal, together with the relief, all the relief sought in her complaint, the costs of this motion, and any further relief just and proper, dated White Plains, New York, September 5, 2000, Anno Domini, yours in truth, Glendora. It's a bad court. No, that won't do it. I have to keep them up. Little Rock, Arkansas. They put out a book, and it's called Your Day in Court. And apparently they send it to pro se litigants. So that's in this book, and they ask you to sign a statement that you read sections 2, 3, 4, 6, and 11. Your day in court, isn't that cute? And so I read, I made up a memorandum, what I think of this. And I read that on another edition. I thanked him, first of all, for filing my case. You know what case it is? That's Glendora versus the New York Law Journal. They wrote an article about public access, and they said everything good about Cablevision and everything bad about public access producers and about myself. And so I sued them. And the name of the owner of American Lawyer Media is a fellow named Wasserstein, and he's the lead defendant. So, let me find you the last page I wrote on this yesterday. I'm up to my hips with lawbreakers who think they're going to get away with it. And I'm going to fight them in court. And now the papers are covering the wand. Okay, this is page 3. Zip code is 10602. United States Post Office had trouble with whatever zip code they used and crossed it out. And in section 4, Glendora says, per paragraph 15, that on page 7, the man on the left looks like William Clinton. And see if you don't think this is true. Doesn't he look like William Clinton? Let me get some more light on. Paragraph 16. Glendora says, philosophic. Thomas Jefferson writes, and they quote him, the judges, therefore, should always be men, of learning and experience in the laws, of exemplary morals. Franklin, this is what a judge should be, according to Thomas Jefferson. Great patience, calmness, coolness, and attention. Their minds should not be distracted with faring interests. They should not be dependent upon any man or body of men. Thomas Jefferson. What do you think of that, Franklin?
Very good.
Have you ever heard that word? Faring? Jarring? Did you ever hear the word jarring? J-A-R-R-I-N-G?
Yes.
Yeah? What's it mean?
I
He said you don't know.
don't know. Jarring word. Tumultuous world. Jarring word.
Oh, they gives you a jar? Like a door jar?
No, like an earthquake jar should.
Oh, okay. Okay, gotcha. Well, Glendora says to the court, it would be so nice. It would be Camelot. It would be utopia. 17, yours, section 144 and section 454 on page 10 are dear to our hearts and exasperatingly elusive in the Southern District of New York and the Eastern District of New York. That's so that if a judge, if you're in a case and you feel that the judge has a prejudice or a bias against you, or a prejudice or a bias against your opponent, then upon an affidavit application, the judge has to step down. That doesn't happen. They violate that law left and right. 18. More than one Glendora fight for right has been ruined by an attorney talking to the judge ex parte. I have in mind Ben Wiles. He was the worst cheater. It should be the way your page 10 says, but it is not. This is Glendora's page 4, a 19 paragraph. Who is the judge on your cover? He looks wasp. Don't you think? Don't you think he does? White, Anglo-Saxon, and American. Schumer was reportedly addressing the impeachment of 18 federal judges. You can see a chat with Glendora on TV in Long Island. Did you know that? He lives in Long Island. He has an office there. Glendora's paragraph 21. Glendora would be jubilant to see a court that does what this book says. Section 5, 22. What court is this? Little Rock, United States District Court in Little Rock. Berger's statement of Federal Rules of Civil Procedure, Rule 1, is good, just, speedy, and inexpensive. That's the Rule 1 of the Federal Rules of Civil Procedure, that you are to have an action, a proceeding. That is 1, just, 2, speedy, 3, inexpensive. Now let me find Berger's. What page was that? Okay. People with problems, like people with pain, want relief. And they want it as quickly and inexpensively as possible. Warren Berger. Glendora's defendants have not yet waived the cost of serving a summons, Federal Rules of Civil Procedure, Rule 4D. She has not heard from him. The attorneys Glendora has encountered are sons, all three. Page 13. Let's see what is on page 13. This is about attorneys. I don't know what all three is. It says once a complaint is filed, the clerk assigns it to a judge by random selection. Then a timetable relating to the various stages of your lawsuit is entered into the docket or court calendar, and the court sends a scheduling order to the lawyers for both sides. Okay, you've seen that happen over and over again. I told you about that. But let's see. Judges can impose penalties to cut down on costly, unnecessary motions, but they would rather rely on the professionalism, reasonableness, and good judgment of the attorneys. I have never seen attorneys with those three attributes: professionalism, reasonableness, and good judgment. I know 3 good attorneys, maybe 4. The attorneys Glendora has encountered are sons, all 3, page 13. Now, what else do I have to read on this? It says that on this blank day of blank blank, being a party in this civil litigation, certify that I received a copy of the publication entitled Your Day in Court, the Federal Court Experience, and have read, or had read to me, sections 2, 3, 4, 6, and 7. So we have covered Six is discovery. I don't think I have to read that right now. Discovery is making the other side tell the truth, folks, and they lie. Oh, you do have to read 6. Discovery. All right, and I have to read 7, and I have to read Rule 11. Okay, that's the last legal paper of the day. I work a half an hour on this, and I will read this, and then I'll tell you what I think of it. I forgot my thinking cap. Section 6 is about discovery. In the Federal Rules of Civil Procedure, Rules 26 to Rules 37 deal with discovery. The book says lawyers don't like surprises. Only on TV do attorneys, clients, witnesses, and court officers gasp because some startling revelation is made at trial. In the real workaday world, the law recognizes that there is no way to resolve a case properly if either side withholds information that is basic to an understanding of the case. As a result, both parties to a suit are required to cooperate in discovery, that is, in the disclosures of facts and documents that closely relate to the case. Discovery happens in several ways: by interrogatories, written questions from one side to the other, requests for admissions, written statements which the opposing side must admit or deny, or depositions, live pretrial testimony before a court reporter and the lawyers of people who have knowledge of the facts of the case. Glendora says, Section 6, if you can make discovery work, Glendora applauds you. All of Glendora's depositions are done by phone and on videotape and audio tape. She can no longer afford greedy court stenographers. The last greedy court stenographer vortexed Glendora into IFP, informa pauperis, vernacular, a poor person. Federal Rules of Civil Procedure, Rule 23, I think, states that depositions can be taken on video. Glendora agrees with the questioner on page 14. And here's what the questioner says. And I do not like the court's answer. Questioner says, my lawyer, paid on an hourly rate, came to my deposition, but just sat there and didn't say a word while I was questioned by the lawyers from the opposite side. Why should I have to pay him for that? I think the person is right, don't you? But this book, the court says, your lawyer was there as a safeguard to see that the questioning was done fairly and your interests properly protected. So I don't like that. I don't like the court taking the side of a greedy lawyer. Lawyers are a rip-off, writes Glendora, and courts have not done their duty preventing these costs from skyrocketing. Rule 1, Federal Rules of Civil Procedure, just, speedy, and inexpensive. Now Section 7, folks, is alternative dispute resolution. Instead of going to court, you have the dispute resolved by a neutral third party. Abraham Lincoln wrote, according to this, discourage litigation, persuade your neighbors to compromise whenever you can, point out to them how the nominal winner is often a real loser in fees, expenses, and waste of time. It would be good, and then we could eliminate lawyers. So Abraham Lincoln is right on page 18. And Glendora tells about the New York Bar Association, City and County. I had a seminar on alternative dispute resolution in their plush Wall Street Palace. The notaries of the area were there. Glendora videotaped it for her TV show. The chief judge of the state of New York, head of the New York State Court of Appeals, was the moderator. He was brilliant, witty, dazzling. Glendora interviewed him a minute afterwards, also. His name was Saul Walker. Nine days later, he was arrested by the FBI, and he was sent to prison. Glendora does not believe there are neutral third parties. Frankly, I just don't believe they exist. Alternative Dispute Resolution 2 has been allowed to run away with costs, and it is sad. The Federal Rules of Civil Procedure, Rule 11, is a sanction on an attorney. That says, every pleading motion and other paper of a party represented by an attorney should be signed by at least one attorney of record in the attorney's individual name, whose address shall be stated. A party who is not represented by an attorney shall sign the party's pleading, motion, or other paper, and state the party's address. Now, the signature of an attorney or party constitutes a certificate by the signer that the signer has read the pleading, motion, or other paper, that to the best of the signer's knowledge, information and belief, formed after reasonable inquiry, it is well grounded in fact that is warranted by existing law of a good faith argument for the extension, modification, or reversal of existing law, and that it is not interposed for any improper purpose such as to harass or to cause unnecessary delay or needless increase in the cost of litigation. And there's another 2-3 sentences. Says Glendora about this. Glendora knows this by heart, Rule 11. She has seen it violated wantonly. She has never seen a United States District Judge impose it. Hi, Ginny. On an attorney who wantonly, it's great to read this between cat's feet, recklessly and crookedly defiled it. I never have. This is great. If this court can do all that it says, I would be exuberant. And that ends this program. And what program is it, Ginny? Read it. Read the number. 2,878. September 5th. 10th edition. If you weren't lying on all the paper, Ginny Cat, I could read the people a joke. Okay, it's not going to make you move. All right. Take care, folks. 2,879. And today is Labor Day. And there are 3 ways that men can wear their hair. Parted, unparted, and departed. Yesterday was a remarkable day, Sunday, and so was Saturday, in that the legal papers were all up to date. And it was amazing how that could happen when we spent all day Friday on the Dolans, on serving the summons, and on printing 16 sets, 31 sheets, 62 pages, on notifying the defendants that Glendora did not withdraw her cause of action on the public access kit number 2, which is illegal and un-American, and then getting out the main paper, which was public access kit number 3 is just as illegal and un-American as numbers 1 and 2. And Thursday all day on Glendora versus Levin, saying that they have no legal basis not to cablecast a non-residence program. This is all over the country. Gerald Levin is the CEO of Time Warner. So, again, it's amazing that after those 2 days, on Saturday, we could get the legal papers up to date. So Sunday, there were just 3 to do. BronxNet, which I read to you, sent to Tom Garger, Cablevision, and then this one, the booklet put out by the United States District Court in Little Rock. So the writing on this is all done. I have read the sections they said to read. I made my memorandum on the same, and now I'm making copies for the defendants. And what is this lawsuit? This is a lawsuit, Glendora versus Wasserstein, an American Lawyers Media Incorporated, the publisher of the New York Law Journal, the editor for Long Island, and the woman who wrote that atrocious article, Julia C. Mead. And wherein they said everything good about Cablevision, everything bad about public access, and about more. And that obviously points to what? They were paid. They were paid by Cablevision. Cablevision puts their money any place except in the shareholders' pockets. They pay off judges. I guess they pay off media. But this was a sellout. Okay, and that's in the United States Court, District Court in Little Rock. And I believe we read to you this page, Glendora's notes on Section 6, which is discovery. It's good for you to know all these things, because your rights are going to be violated, and you've got to go to court to stand up for your rights and to get your rights. And it's good for you to know all these things. And go pro se. Do not hire a lawyer. Whatever you do, do not hire a lawyer. The lawyer will double cross you in the end, or maybe in the middle, or maybe in the beginning. But the lawyer will double cross you. Okay, we just pinned it page 5 of the memorandum and page 6. Franklin slept from 9 p.m. last night to 8 a.m. this morning, 11 hours. He does that quite a lot. And after I read you this legal paper yesterday, which is on the other edition, this is the 11th edition, that one's on the 10th edition. It took an hour and a half to tidy up this place and to get a dinner and to get the clothes dry that weren't dried in the laundromat, in the dryer. And the dinner had to take a lot of time because that's my last one. This is today, Labor Day. And I start on the diet. I'm 179 pounds. That's too much. I'm not one to throw my weight around. And the diet is that I fast until 4 p.m. every day. So after that was done, I telephoned 10 calls. I telephoned 10 people. And I don't know if you want to hear any of those or not. And I screened the audio tape of our looking at the shareholders list, Cablevision, for which we fought very hard as you followed the whole thing. And that's a good audio tape. And then prayed for today, Sunday, and telephoned another 10 people equal 20, and another 10 people equal 30, and another 10 people equal 40. Franklin read the idiot sheet, the sporting news, the baseball scores, and finished one of the Times. He's behind 2 or 3 of them, New York Times. And then started Med-Create, and then on schedule at 8:30, get ready for bed and sleep from 9 to 5. Sleep 9 to 5 like Cablevision employees. Only it's the other 9 to 5. Labor Day? Any rest? Nope. Just like any other day. Legal papers, telephoning, details, but no errands. At least it's an in-day. An in-day is nice. And the 13 chores. The cats and the litter pans, and clean up the kitchen, and the compost and the rubbish. And feed the cats and tidy up. And then finally just sit down and close yesterday. Be aware of all of the wonderful gifts of God of yesterday. And then plan today. Every morning. And then the logs. Brad Sachs likes a short log, and then there's the regular log. the condensed log Brad Sachs likes. And then comes the first legal paper. And that's Glendora versus the New York Law Journal in the United States District Court, Little Rock, Arkansas. So, everything's been read to you up through page 6, and this is page 7, and it says, conclusion. Glendora commends the court on the book, Your Day in Court, for having same and for mailing it to litigants. She will follow it. She prays to God, all others will. She served the certificate of party together with a book and her memorandum on same to all defendants. Service was by U.S. mail on September 5th, 2000, Anno Domini, dated White Plains, New York, September 5th, 2000, yours in truth. The certificate of parties says that you have read sections 2, 3, 4, 5, 6, 7, and 11. Page 8 is the envelope with the book that came in. I think it's important to save envelopes. And so, yesterday the legal papers got up to date, praying was up to date, shirt, Rocky, laundry, the 13 morning shorts, Meditate Create, and 40 telephone calls. That's all the days of hold that the 14 companies. This is the United States District Court, Little Rock, and it's a certificate of parties, and I signed it on the 5th day of September 2000, I, Glendora, being a party in the civil litigation, certify that I have received a copy of the publication entitled Your Day in Court, the Federal Court Experience, and have read or had read to me sections 2, 3, 4, 6, and 7 thereof, and also that part of Rule 11 quoted on page 26. And I further certify that I understand the requirements imposed upon me as a party in this civil case. Glendora. So that's page 9. And page 10, I guess, is going to be blank. Page 11 is the certificate of parties, and it's blank for each defendant to sign. So, a spiral notebook, it was such a big help in writing it, can be put away for another legal paper. We have to make 9 sets of this. On the back of the defendant's certificate of parties, we will put the court's proof of filing, the complaint, and the date of filing, and the name of the judge. Well, they put it to a magistrate judge. I made a mistake. It's not the Eastern District of Arkansas. It's the Western District of Arkansas. But thank you, court, for correcting that for me. Now I'll start copying the booklet. Your Day in Court. The federal court experience. It's 1, 2, 3, 4, 5, 6, 7, 8 sheets back to back. So that will take a while. A man named Bob said that he read in the Bible that the very hairs of your head are numbered. And he says it's getting easier every year to take the inventory. It's done, folks. It's 11:30 in the morning, and here it is. It's all done. 32 pages, and the costs on it were 7 3/4 an hour plus a half an hour, and $20.84. And the total time on Glendora versus the New York Law Journal is 25 3/4 hours and $64.61. But we found a good court. And here they are. One to each defendant, one to the court, one to the Public Service Commission, one to the Center for Judicial Accountability Incorporated, and one to you, Glendora's TV audience. So that calls for a rest. That calls for praying. This is some pretty color paper that Franklin bought. And this is the to-do sheet. Every day, to-do sheet. A list of what has to be done. And since it's September, a new month, we have to have new to-do sheets, and you go by the electromagnetic spectrum: red, orange, yellow, green, blue, violet. So we just finished with violet. Now we're going to do pink. This is the second and final legal paper of the day, and this is the Indianapolis Court, the United States District Court. And a judge there named S.Q. Dillon, a senior judge in right now, dismissed my case against the Neanderthal court officer, 1763. And the judge even gets the number of the court officer wrong in the caption. He calls him 1764. And he leaves out court officer, 1763. And the judge even gets the number of the court officer wrong in the caption. He calls him 1764. And he leaves out two defendants in the caption, so this is really some judge. And so it's supercilious, and it's superficial. And I have written my opposition to it. And it's completed now. I just finished writing it. So the next step is to make 11 sets. Collate them, fold, stuff, and seal. And I read on another edition what was wrong with the paper. And so now I'll resume and read the rest to you. I read you the notice of motion in motion, and this is the affirmation in support. I read pages 1 and 2 to you, and this is page 3. It is self-interest. It's the judge's self-interest versus your interest, the public interest. This is not a police state. The United States of America is a republic. Remember, I pledge allegiance to the flag of the United States of America and to the republic for which it stands. It is not a police state. This is a case of police brutality, and you are on your own selfish side and not the public's. Glendora sued 2 judges. As a judge, you don't like that. She sued a Neanderthal court officer whose job is to protect bad judges. You don't like that. Meaning the judge doesn't like that. Glendora needs a judge who remembers the courts belong to the people. Glendora's case meets the jurisdiction requirements. Glendora's case states a legally valid claim. Glendora's case has genuine issues of material fact. Glendora is constitutionally guaranteed the right to a civil trial. Dillon is trying to force Glendora to give up that right. She will not. Like an order to show cause, Glendora requests that Dillon to show cause why her case should be dismissed. Rule 11 sanctions should be imposed on S. Hugh Dillon. And this is Rule 11, that Dillon did not act in good faith. And here is his bad order, which I read to you, and refuted, and I read that to you. And that was page 6. This is page 7. Here is the judgment, which I showed you before. I annotated it. It says, it is therefore judged that the cause of action is dismissed for lack of jurisdiction, and Glendora says he's dismissing it for lack of good judgment. This is the envelope that the court sent. Glendora's name, handwritten. That's page 8. And here's page 9. Wherefore plaintiff Glendora seeks relief from judgment or recusal, together with all the relief sought in her complaint, the costs of this motion, and any further relief just and proper, dated White Plains, New York. It will be Labor Day. And the cost of this paper is tallied here. 19 hours. And, excuse me, that's wrong.